Hello, everyone. Welcome to our monthly IP webinar. Thank you for joining us today. Today, our topic is legal insights into trademark infringement and unfair competition in China. During the 30 minutes webinar, we will cover the following. The first is what's trademark infringement. Second is what's unfair competition. In the third part, I will share two cases with you in respect of judicial rulings on the misuse of others' registered trademarks in company names and domain names. The fourth is key takeaways. Before starting, please let me introduce myself briefly. My name is Gina, and I'm the registered attorney and part of the Gufu Wenjia Law S&O IP Beijing office for around 4 years. I'm specialized in litigation, particularly trademark and copyright law. By the way, if you have any questions during the webinar, please feel free to submit them to my email box, and I will refer to them at the end of my presentation. Okay, let's begin. Let's first take a look at the first part. What's trademark infringement? Article 57 of PRC trademark law stipulates the main manifestations of the trademark infringement in IP cases. It's mainly divided into 7 aspects. Let's take a closer look and say what they are. Due to time constraints, let's cover the most important part first. If time permits, we will come back and continue with the rest of the content. Article 557 stipulates that any of the following acts shall be deemed as infringement of exclusive right to use registered trademarks. The first paragraph, use of a trademark identical to a registered trademark on the same type of commodities without listening by the trademark registrant. This article is regarding the usage infringement on a trademark. Usage infringement is a common type of trademark infringement in practice. If one party uses another party's registered trademark on the same goods without consent, regardless of whether it's intentional or not, it will constitute infringement of the exclusive right to use another party's registered trademark. Let's say the second paragraph. Use of a trademark similar to a registered trademark on the same type of commodities without listening by the trademark registrant, or use of a trademark identical or similar to the registered trademark on similar commodities, which can easily cause confusions. The second paragraph is a supplement to the first paragraph. It usually refers to 3 situations. The first is using a trademark similar to the right owner's registered trademark on the same goods that can easily lead to confusion. The second situation is using the same trademark as the right owner's registered trademark on similar goods that can easily lead to confusion. The third situation, using a trademark similar to the right owner's registered trademark on similar goods that can easily lead to confusion. The third paragraph is regarding the sale of the infringing product. It means the sale of commodities which infringe upon exclusive right to use registered trademarks. The above 3 paragraphs are the most common type of trademark infringement. As for the 4th to 7th paragraph, let's go through them briefly, and I will give you 10 seconds to read for yourselves. As for the seventh paragraph, causing harm to others' exclusive right to use registered trademarks. Regarding this article, Article 1 of Interpretation of Supreme People's Court on several issues concern the application of law in the hearing of civil cases involving trademark disputes make it clear. Let's take a look at what Article 1 specially says. Article 1. The following acts shall fall under acts causing other harm to others' exclusive right to use registered trademarks as stipulated in Item 7 of Article 57 of the Trademark Law. Using words identical or similar to others' registered trademark as an enterprise name and prominently using them on identical or similar goods so as to likely cause misidentification among the relevant public. Let's just look at the third one, registering words identical or similar to others' registered trademarks as a domain name and conducting e-commerce business in related goods through the domain name so as to likely cause misidentification among the relevant public. Registering words identical or similar to others' registered trademark as a domain name or an enterprise name, anti-unfair competition law of the PRC also contains relevant provisions. Let's take a look. Article 6 of Anti-Unfair Competition Law stipulates that a business shall not commit the following acts of confusion to mislead a person into believing that a commodity is one of another person or has particular connection with another person. Using without permission another person's name with certain influence, such as the name, including abbreviations and trade names of an enterprise, the name, including abbreviations of a social organization, or the name of an individual. Using without permission, the principal part of a domain name, the name of a website or a web page with certain influence among others of another person. How to distinguish whether an act constitutes trademark infringement or unfair competition? Let's first take a brief look at what constitutes unfair competition behavior. The anti-unfair competition law mainly stipulates 7 types of unfair competition behaviors. Simply put, they are commercial confusion behavior, commercial bribery behavior, false advertising behavior, infringement of trade secrets, improper price sales behavior, defamation of goodwill behavior, unfair competition in the internet field. Among them, the part in respect of domain names and enterprise name is a common commercial confusion behavior, which is subject to Article 6 of the Anti-Unfair Competition Law. Confusion behavior is commonly referred to as brand imitation, which refers to the act of counterfeiting someone else's product logo, enterprise entity logo, production and operation activity logo, etc., in order to mislead people into thinking that one's own product is someone else's product or has a specific connection with others in order to borrow the influence and reputation of others or their products and improve one's own product's market competitiveness. Before we look at the case, let's again briefly review the relevant laws and regulations. regarding using someone else's registered trademark in a company or a domain name. I will give you 10 seconds to respectively read the content again. Based on the above, we could conclude that using someone else's registered trademark in a company name or a domain name may constitute trademark infringement or unfair competition. Through case studies, let's take a look at how judicial practice deals with these situations. For the first case, let's say the case summary firstly. The plaintiff, Honeywell International Incorporated, is the right owner of the trademark Garrett and English-Chinese Garrett, 盖瑞特. The defendant, Mr. Tong, is the registrant of the trademark 盖里特. And the defendant, Shanghai Garrett Turbocharger System Co. Limited, is a one-person liability company invested and established by Mr. Tong. The plaintiff found that the defendant Garrett Company, without authorization, marked the same and similar Garrett, Carrot, and Garrett logos at the plaintiff's registered trademarks Garrett on the turbocharger, seeds produced and sold. The defendant Garrett Company intentionally used not only the Chinese 盖里特 trademark on unproved automotive turbochargers, but also the unregistered Chinese and English Garrett 盖里特 combination trademark on products and packaging, highlighting the word Garrett. Garrett Company uses websites with domain names. We can say from the PPT, they use these three domains for its business activities. The third, the word 盖里特 in the company name of the defendant is similar to the Chinese and English pronunciation of the plaintiff trademark. Therefore, the plaintiff filed a lawsuit with the court requesting an order. The defendant shall say the trademark infringement behavior. They should change its corporate name and not allowed to use the word 盖里特 and stop using the domain name. Also, they asked the defendant to compensate the plaintiff for economic losses of RMB 500,000. Let's first say the court's determination of the mark used by the defendant. To make it clear, let's say the chart. As for the mark, we could say that Garrett 盖里特 is a mark the plaintiff registered. The defendant used, in fact, is the Garrett 盖里特, and the court finally held that the mark constitute similar trademarks. As for the goods, we could say from the chart, the goods designated by the mark registered by the plaintiff is turbo machinery, auto parts, and the goods the defendant use are turbochargers and related accessory products for automobiles. The court finally held that they constitute similar goods. Then the conclusion is that they constitute trademark infringement. Then let's say the court's determination of the domain name used by the defendant. The court held that the domain name registered by the defendant, Garrett Company, are similar to the plaintiff's registered trademark, Garrett. Second, the defendant, Garrett Company, conducts e-commerce related to turbocharger products of the same type as the plaintiff through this domain name, which can easily cause confusion between the relevant public and the plaintiff's products, and also mislead online users to visit its website. The third, the defendant, Garrett Company, has no evidence to prove that it has any relevant rights to the main part of the domain name Garrett, nor has it provided a legitimate and reasonable reason for registering and using the domain name. The fourth, due to the fact that the defendant knew that the two trademarks owned by the plaintiff were well known in the same industry, the defendant, Garrett Company's registration and use of domain names had the subjective intention of causing confusion with the plaintiff's products and misleading online users to access their website. Therefore, the defendant registered and used the domain names for similar community transactions for commercial purpose, causing confusion among the relevant public, which constitutes infringement of the plaintiff's exclusive right to use a registered trademark. Next, let's say the court's determination on whether the defendant, Garrett Company's registration of the Garrett trademark constitute unfair competition. From the PPT, we could say that the court held that the first, due to the fact that both the plaintiff and the defendant, Garrett Company, have business operations in turbochargers and related products, they have a competitive relationship within the industry. Second, the two trademarks used by the plaintiff were both used prior to the defendant, Garrett Company's use of its business name. Third, the similarity between the 盖里特 trademark and the plaintiff's Garrett 盖瑞特 trademark can easily cause confusion and misidentification among the relevant public. The fourth, the plaintiff's Garrett 盖瑞特 trademark enjoys a high reputation in the same industry. The defendant knew that and still registered its business name with the fictitious word 盖里特. Its subjective malice is obvious. Based on the above, even if the defendant, Garrett Company, uses its corporate name, normally it still constitutes an infringement of the plaintiff's rights and interests, undermines the fair market competition order, and constitutes unfair competition against the plaintiff. This is the first case. Let's move on the second case. This case is one of the top 10 IP cases tried by Chinese courts in 2023, published by the Supreme People's Court. The same, let's firstly refer to the case summary. Sai Redacted AG and Sai Redacted China Co. Limited were the right holders of the registered trademarks Siemens and Simons. The trademarks registered on products such as washing machines gained high visibility through the long-term use and vigorous promotion and publicity by Sai Redacted. Ningbo Qi Redacted Electronic Appliance Co. Limited and others registered the name Shanghai Siemens Electric Appliance Co. Limited overseas and widely used it as a commercial sign on the washing machines they produced and sold, on product packaging, as well as in related promotional activities. Sai Redacted sued in court, alleging that Qi Redacted and others infringed its exclusive right to use its registered trademarks and committed unfair competition. There are many inspirations from this case we can learn. Since the focus of today's topic is regarding using someone else's registered trademark in company name or domain name, let's just look at the court ruling from the two perspectives. I will give you 10 seconds to read this first. The left side is a first instance court's opinion, and the right side is the second instance court's opinion. Finally, the Supreme People's Court rendered a judgment dismissing the appeal and affirming the original judgment. And let's firstly say the court's determination on whether the use of the accused infringing name, Shanghai Siemens Electronic Appliance Co. Limited by Qi Redacted, infringes on the trademark rights of Psi Redacted AG and Psi Redacted China Co. Limited. The court held that the use of the name can be divided into three situations. The first is used on the washing machine body. Second is used on the washing machine packaging. And the third is used in promotional activities. Let's first say the situation of using the name on the washing machine body. The Supreme People's Court held that the name was prominently displayed on the machine body panel and easily used by the relevant public as a means of distinguish the source of goods and should be considered as a trademark. Generally speaking, it's not reasonable for the company to permanently label the company name of another person on its own product. It can be seen from that Qi Redacted's original intention in using the name was to use it as a trademark rather than as a company. Qi Redacted used the Shanghai Siemens Electric Appliance Co. Limited's name on the washing machine body, which is similar to the goods in Class 7 washing machine products approved for use with the trademark Siemens. The third, in the name of Shanghai Siemens Electric Appliance Co. Limited, both of Shanghai and Electric Appliance Co. Limited are lack of distinctiveness. However, Siemens has strong distinctiveness and recognition, which is exactly the same as the trademark Siemens. Therefore, this name constitutes a similar trademark to the plaintiff's trademark Siemens. Therefore, using the accused infringing name on the washing machine body infringed on the exclusive right of Psi Redacted AG and Psi Redacted China Co. Limited. Let's say the second situation. The situation of using the name in product packaging and promotional activities. The court put these two situations together to comment. Normally, production companies will label the relevant company name on the packaging and promotional activities of their products. In this case, Qi Redacted declared that the accused infringing product was its own product and it was authorized to use the name legally. Since labeling the company name on the product packaging and promotional activities is a normal business behavior, thus, the sued behavior of Qi Redacted meets the legal requirements and should be handled in accordance with the anti-unfair competition law. Therefore, through the aforementioned laws, regulations, and cases, we can gain the following key takeaways. The first, trademark use is essential for establishing trademark infringement. Non-trademark use may fall under before the scope of unfair competition. If one party uses someone else's registered trademark in the domain name, the first step is to check whether the use of the trademark in the domain name meets the conditions for infringing the exclusive right to use the trademark. If not satisfied, check whether it constitutes unfair competition. The third, if one party uses a company name in a manner similar to a trademark in the product body to identify the source of goods, it shall be deemed as trademark use and constitute trademark infringement. The fourth, in cases without a prior registered trademark, protection may be sought through unfair competition lawsuit. Before concluding this hearing, let me quickly check my email box if we received any questions. Let me check. Please wait for a second. Oh, I received several questions. Since time is limited, I will just pick a typical one. The question is, what usage behavior can constitute trademark use according to Chinese law? Well, the provisions of PRC trademark law on the use of trademarks have special meanings, and not all use of all other people's trademarks falls within the scope of trademark law. For example, Article 48 of the trademark law stipulates that trademark use shall mean use of a trademark on commodities, commodity packaging, or containers and commercial transaction documents, or use of a trademark in advertisement and promotion, exhibition, and other commercial activities for identifying the source of commodities. Please note that only the use of trademarks in the sense of identifying the source of goods or services belong to trademark use in the sense of trademark law. Well, I think we're running short of time and my presentation should be over. If you have any questions or requirements, please send us an email, as our legal team is eager to assist you in handling your IP rights protection matters in China. Thank you all for your attention. Bye-bye.